I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. Today, we are diving deep into a groundbreaking piece of legislation that's poised to reshape the digital landscape, the EU Data Act. What is the EU Data Act, you may ask? And why should you care? Well, its authors see it as pretty big. They envision a world where data flows freely, where innovation thrives in the digital space and the digital economy reaches new heights. Through that lens, the EU Data Act is a blueprint for this future, aiming to democratize data access and ensure that individuals and businesses can harness the full power of their data. Will that be successful? Well, we'll see. But in the meantime, I think we do know that one thing is true. The digital landscape in Europe and likely elsewhere is going to change. And that's not just for B2C relationships, but for B2B too. The rules are changing to require robust data portability and interoperability. Frankly, the ability of moving data from point A to point B easily and having two systems work together. Data rights and ownership will fundamentally change. Data will be de-siloed. Competitive advantages that were long built and earned by creating proprietary data sets and amassing exclusive insights through data concentration will be upended. And frankly, I think that's just the beginning, because this law is really at the early stages, and we are going to spend a significant amount of time understanding the consequences and implications of the legislation. To accomplish something of that scale, you can imagine that significant effort is needed. Fundamental expectations around data will need to change, starting with basic concepts of who owns what. For example, a SaaS service may create significant amounts of data in the ordinary course. Things like system data and usage data, telemetry, statistical counts, and other metadata, which is very different than what we would think of as the customer data or the data that's inputted into the particular service. All of that metadata, all of that information that was largely taken for granted, that may no longer be the exclusive asset of the platform. And what's more, the SaaS platform may need to restructure its operations so that it can provide all of that data to a user or another designated service. Peer and competitive systems may now need to speak to each other more easily and have the user, not the platform, control how that data moves. There is a lot here. To break it down, I'm going to create 3 initial episodes for you. Today's episode will provide an overview of the law, its scope, how organizations will need to comply, the basics. Then we'll also drop 2 more episodes that have a specific focus. 2 types of entities will be most directly impacted by this law: cloud providers and connected products and service providers. Now, to be fair, those are 2 huge categories. It's frankly hard to find any services nowadays that don't have a cloud or a connectivity component. But the implications for those 2 sectors, those 2 markets are so big that they deserve their own separate conversations. So if you're listening to this, make sure you tune in to those other 2 episodes if you really want to fully understand the Data Act's implications and what will be needed to comply with them. But in the meantime, let's get started. I've invited 2 of my colleagues to the podcast, Christian Tinnefeld and Henrik Hanssen, who are both located in the Hamburg, Germany office and are advising companies daily about all aspects of data protection, AI, and now the Data Act. So excited to have them both and to share their insights with all of you. Christian, Henrik, welcome to the podcast.
Thank you for having us here.
Maybe we just start at a high level, because I think I would benefit, and I'm sure the audience would benefit from an overview of what the EU Data Act is, because there's clearly so much going on in Europe. And later, I would like to understand from your perspective how this fits into the larger network of laws that are being built here. But the EU Data Act, as I understand it, it's going to have wide implications, but it's really not well understood. So, just high level, kind of walk through what the law is and what it's intending to accomplish.
Yeah, if you want to understand the EU Data Act precisely, then you have to take a step back, or probably even a couple of steps. And this takes us back to 2020, when the EU legislator introduced what they call the European Digital Strategy. And this European Digital Strategy that was introduced by the European Commission, and you can find much of content on their website if you want to have a deep dive. This aims at a, if you want to call it like digital decade until 2030. So the European legislator, they created something like a project plan for different types of new regulation to come for a certain set of purposes. And the purpose, the overarching purpose is to create a single market for data, which is unknown yet or has been unknown yet, and with the aim of creating a free access, fair, and secure data flow. Why is that? Well, because the European legislator, they analyzed that so much data is available from connected products, from data processing services of any kind, that sits in silos at certain companies without a free flow. And the European legislator want to unlock this silos and want to open the data to society, to new small companies, so that they can develop new ideas, new businesses, and to foster and to make the data available and free flowing for society, for small enterprises, to develop new businesses and new purposes for the data use.
So interesting, Christian. And I want to pause for that moment around market, because I think that will probably have many different meanings. What we're not talking about here is the trying to open up the ability of buying and selling this information. I think what we're talking about, if I'm understanding it correctly, is it's more for the various products and services that are out there, for all of the data that's being collected about that, for that data to become accessible and perhaps mobile, meaning that it can move from one system, one product, one service to another product without it necessarily being locked in to the infrastructure where it was originally created. Is that the right way of understanding this?
Yeah, I think so. So there are, let's say, two pillars. One is about connected products and digital devices and services, and the other one is for processing services. And let me start probably with the first one, and Henrik can chime in for the processing services. So the first pillar is to make data accessible, product data that is being obtained, collected, and processed by so-called connected products, meaning Internet of Things. So this can be a machine connected to the internet or a dashboard. This can be a medical device. It can be smart home products, or it can also be vehicles in agriculture. So all of these devices, if you want to call them like that, they collect this amounts and tons of data every day, every second, every microsecond. And this flows into certain data spaces or databases, basically, or cloud environment, and stays there. And the idea is to make this accessible for the users of these products and to give them the right to decide whether they want to use and analyze it or whether they want to have it transferred to third parties. So this is the idea about the connected products and the related services, which are apps or dashboards or whatever is needed to steer these connected products.
Yeah, maybe Henrik, I'm interested in your perspective about how to think about what data is within scope, because Christian's making the very accurate point that there's so much data that's being created. And, at the very least, my guess is that like call it the customer data, the user data, the things that are specifically inputted or created about the person, about the individual who's using it, about the customer who's using it, all of that maybe is more clear. But as Christian is also pointing out, there is a whole lot more data that's being created in connection with the use of any type of online platform, whether it's cloud, whether it's connected, essentially if it has any connection to the internet. Sensor-based data, for example, is all over the place. Metadata that's being created relating to the use of a SaaS-based platform. Where to draw the line between what is the user data or the data that relates to the user versus what is the data that rightfully belongs to and is only linked to the provider of that platform?
That's a really good question and also a core question under the Data Act. So there are a couple of points here, actually. So when talking about user data, we are, first of all, not only talking about the Data Act, because, we have also the GDPR when we have personal data involved. But what the Data Act is doing is it approaches data on a very broad and general level, and it introduces many new definitions of data categories, actually. And this depends on whether we are speaking about connected products, like Christian has mentioned, or whether we are looking into the provisions on data processing services. And generally, the Data Act, or the goal of the Data Act, is to make as many data types accessible to users and to the economy as possible. That's the underlying purpose. But then there's, of course, as you've mentioned, an interest of service providers, of course, to retain the rights in data that the service provider has created and derived from data created by the machine or entered by the user. So, and to make this distinction, we find many definitions in the Data Act, like product data, service data, derived data, all in combination with personal data under the GDPR, where we must make a clear distinction for what is in scope of these different data types in practice, and whether the data can be accessed then by the user, let's say for connected product, or whether the service provider or operator of the data holder for the connected product can secure its own rights on these data types. So that's on a very general level. I think we can maybe later discuss the details on the data types, but this really is the overlying issue that we are currently see for the Data Act implementation.
So, Henrik, that's a really helpful explanation, and there's clearly a lot of complexity. I want to draw out a couple of the things that you said, because I think you were mentioning that this is not only limited to B2C data, which in some cases is going to be easier. I think it's also covered by B2B data, and that strikes me as maybe much more difficult to decipher, especially when you're thinking about the complexity of the online ecosystem, right? The supply chain that exists amongst SaaS providers and software for providers, because many of them are not just working in the silos like they created everything themselves. They're relying on other third parties. Well, let's just say that I'm a SaaS provider and I'm leveraging one solution which I make available to many customers, but I'm using one common set of subcontractors to be able to help me do that. I have, one set of a CDN, for example, to help push out this content. They're generating all sorts of data, IP addresses of who is, pinging our system, who is being able to access our system, device IDs about what types of data that's being collected, geolocation information about where those people are located, total volumes of data coming in and out of those platforms. And that is true for customer one through customer 1000. And so to me, this strikes me as difficult to figure out how is it that I have a one-to-many model, but yet I'm trying to figure out which data belongs to which entity, and then trying to associate the rights that are inherent within the Data Act in a way that is manageable because much of this, my guess is, it will be unclear to what extent it relates back to a specific customer or a specific user.
Yeah, very good points. And this is really where our clients and companies are having their biggest homework yet, because they need to do a full data mapping exercise to identify the data that are actually within the scope of their obligations under the Data Act. So when talking about the SaaS providers in the cloud computing space, the Data Act helps us a little bit because it has definitions of the data that must be made available under the switching requirements, which includes exportable data, and there's a definition for that. However, this definition is very broad, so it includes any input and output data. So talking about business customers is pretty much any data submitted to a SaaS service by the customer, but also content and data created on that basis by the service. And it can also include automatically generated and co-generated data, so specifically metadata. So this would be also in scope. There are exceptions for certain types of data from that, but this doesn't really relieve you from the exercise and from the need to perform the data mapping exercise. This also comes along with transparency obligations. So it's not just that service providers are required just to identify and specify the relevant data categories, but also to make available a register of data that are actually subject to the switching requirements. So this makes it very transparent, first for the customers, of course, but also for, let's say, regulators or third parties checking on how the service provider in question actually fulfills its Data Act obligations.
Yeah. And if, I think one of the implicit things you described, Henrik, was a data mapping exercise, for those who haven't gone through that effort, effectively trying to document and identify all of the ways that data is coming in and out of an organization. And that's kind of data with a lowercase d, like all of the different types of data for this purpose. But it also strikes me that imperative for compliance with these obligations is going to be data classification. And because given the number of different defined terms and to the extent that those defined terms are going to be treated differently as you're describing, it's not only good enough to know what is it that data that you have, but you also need to figure out how to bucket it and frankly tag it so that you know what type of data needs to be able to move and perhaps what type of data would be exempt or not applicable for this law. Do you see it the same way?
Yeah, absolutely. It's a challenging exercise and certainly requires some resources to carry out the data mapping exercise. The good news here is that if you haven't done it before, this exercise also helps to get a better understanding on what data is actually available and can be also maybe used for own purposes, for example. So it's not that the data mapping exercise should be regarded as a mere compliance burden, which it is, of course, to some extent, but it can also be helpful in terms of getting to know better the own data inventory, so to say.
Well, the biggest benefit that we see at clients at the moment, because we have a handful of clients that we support in this data mapping exercise, and true, it's one layer is to comply with the new requirements under the law, but it also helps companies understand where their data sits and which type of data. So it's a data governance exercise, and we sometimes cooperate with data analytics companies who have a different perspective on the same exercise, because they often call it like a data inventory that they create, or a data catalog, with their purpose to identify data that is relevant for certain purposes, for instance, data analytics or maintenance or whatsoever, and to overcome a situation that you described at the very beginning, Scott, where the data is just collected, let's say, not randomly, but in a very unsorted way. And now that the task is from their perspective, so the data inventory guy's perspective, to, let's say, sort the data and to give them a certain tags for certain purposes, so that they can be used for certain operations. And this is perfectly chiming into the data mapping exercise that we are looking at from a legal perspective, because, like, for their purposes, we have to push the clients, the companies, to an understanding that they should be aware of where is the let's say, confidential information in their data, which type of data is related to individuals, like you sketched in the last question. So if someone is asking for a certain data set, is he really entitled to, or is this the data associated to a third party? And there are different other categories. So, like, for instance, you are not obliged under the Data Act to disclose content, so which is again data, obviously, or certain data that you have made an investment in by analyzing it, by merging other data with the raw machine data. So this is the so-called derived data. So there are many, many reasons to do this tagging exercise and to create a solution, a platform solution, where you can easily identify, access, transfer all these types of data. And this is now the time to do it, because when we look at the companies, at least many of them, they are in a very, let's say, legacy way of collecting this data. And when we start doing these projects, then they sometimes learn about their own data and infrastructure setup. That's very interesting.
Yeah, it's a good point, Christian, and maybe one to also dive into just a little bit more, because one of the questions I have is around, well, what does this law require us to do? So you described that it has a lot of application to different types of data. You described that, like, it would require essentially to de-silo and to allow for the accessibility of this information. I think the next question I think many organizations would have is, well, how do I need to do that? Because is this a scenario where, you get a letter and the letter says, please give me all of your data, and then you go and you put it up on a thumb drive and you mail it back to them? Can't imagine that that's what they do anymore. But is there a technical investment that's needed here? In other words, in similar kind of laws that are popping up in the United States, relating to interoperability, to essentially allow two different systems to speak to one another without proprietary data stopping the ability for one data set to move, for data to move from one system to another. There is significant technical effort to allow for that. You have to have data in a consistent standard. You have to have data in a way that's not going to be locked up. And then, the question is like, well, is this something I have to hit a button for to allow for that data to move over? In which case I need to build the button and I need to build the pathway. Or is this just a legal exercise where all of a sudden this is going to be coordinated by lawyers, which my guess is for many of the lawyers who are listening would say, I do not want that to be my responsibility to go through all these data sets and figure out which one relates to which user.
Okay, this is interesting, because I think you asked one question for the two of us, because it all depends on the type of service or the product. And the answer to your one question can be very different depending on which type of product you are offering or which type of service you're hosting. Probably, let me quickly start with the products. Just assume you have a smart product, a smart home product. Let's say you have a kitchen device that is connected to the internet and that collects data, and then you can share the data, etc. So this producer may have a a different range of products, right? So, and one is more ancient and the other one is top notch and very modern, etc. So they have to look and to examine which type of products they have and how this specific type of product is collecting and processing the data, because there are the Data Act is in a way technology agnostic. It allows you to have a product that is connected to the internet and to arrange for a setting where the user can download the data directly from the product. So it can be on device. Second, the connection can be like with a physical connection. You can have a cable connection to the product, and then you can probably download it yourself by an associated app that you have, a mobile app. So this is a second option. And then, and I think this is driving more and more towards this scenario, it can be obviously connected wireless, let's say to a Wi-Fi environment or to a cloud. And then the question is, if I have if I'm a registered user at an online service at a client or customer who produces and manufactures these products, there I can access that one, the platform, and then I can ask for, hey, give me my data. I'm a user. Obviously, there are so many questions around this. So you need to have some proper authentication, yeah, so that the right person is asking for the right data. You have to check their entitlement. You may want to include certain terms and conditions for this service. And then you have to consider, okay, what is the technical mean by which I provide this data? Probably as a download, probably like a link or whatsoever that points me to a certain storage space. And then there's obviously IT security questions, so that I do not open the data and let it flow to an unauthorized third party. And in this environment, there are two types, and then I pause for a moment. There are two types of very different claims to consider. And it's relevant in terms of timing. By September 2025, so in almost half a year, companies in Europe that provide their products here and put it on the market and have their users here, they can face claims by these users for access to the data, and they are required, quote unquote, only to provide this data upon demand. So in a way, manually, right? So you post your request, and then the company can go checking what is the relevant data, pack it together, and provide it. Fine. Only 1 year later, the European legislator at least expects you as a standard to have a solution in place that by design provides you with immediate access, meaning that the user can, in a self-service mode, enter a platform, enter the product, and get the data on its own without any interaction or permission or manual activity of an agent of the company. So this will be a very tremendous shift, and many companies are working already now on this disclosure solution because it's time consuming and it's difficult to design.
Yeah, it doesn't work with just waving a magic wand either. My guess is that this is going to be really difficult to implement. If I think about how to take that forward, I think one question then, Christian and Henrik, is going to be, well, how do I approach this set of issues? Henrik, you made the comment around data mapping, data classification. To what extent is this negotiable? Because many organizations, when they're entering into different types of terms to access these products, are entering into terms of service, to entering into different specific customer agreements. Those could be bespoke, those could be enterprise level, kind of off the shelf, click-throughs. To what extent is this something that can be adjusted through contract, or is this the new state of play that everybody has to adhere to the same types of rules regardless of contractual relationships?
That's a very tricky point, and one of the core issues as well. And we here again must make a differentiation between basically the connected products section on the Data Act and then the data processing services. In both cases, the European legislator made some very clear limitations and set forth requirements for what can be stipulated in contracts with customers and users and what cannot. Some find this very intrusive in terms of contractual freedom. But this is how things are currently. So there is a non-negotiable aspect in any case. So, for example, for the cloud contracts, cloud agreements, the legislator provides a full list of requirements that must be fulfilled for cloud computing contracts going forward. This will certainly change the cloud computing landscape, at least from a contractual perspective in the EU, to a fair big amount, I think. So, yeah, there is nevertheless leeway for providers to find their own provisions and make create own contractual clauses, create and specify the definitions of exportable data, but this must all happen within the boundaries of the Data Act.
So what I hear you saying, Henrik, is that the contracts can't get around this entirely, but they will require some additional thought about how to approach this, and there is areas for negotiation. But what I also heard you say is that there are now expectations around what those contracts are going to say that didn't exist a year ago. And that is going to probably set off light bulbs in many of our clients and organizations' minds, because that means that every cloud agreement, every connected device agreement, kind of every agreement that has for a product or service that's connected to the internet, which I don't know, maybe is all of them, all of those need to be renegotiated. And that would be a heavy undertaking, especially when we're not only talking about customer agreements. If this is the case that data has to flow up and down the supply chain to enable that mobility, then you would need to have all of the subcontractor relationships also be addressed. In other words, if you have a SaaS provider who says, sure, you customer can gain access to all of the data through in compliance with the Data Act, and then their subcontractor to that SaaS provider who's maintaining the underlying database, they have no way of doing that. Well, then no one's going to actually get that to be right. And there's probably going to create all sorts of disputes and non-compliance. Am I thinking about that right? Or is this more narrow?
Yeah, I think the key takeaway here really is that the Data Act is a massive contract management project as well, because it impacts, for example, when talking about SaaS solutions, basically all cloud computing contracts with users in the EU, and those need to fulfill the requirements of the Data Act. And there's no really a workaround if you want to be compliant. And it basically, so from a contract management perspective, adds an additional layer of complexity to a contract. So we now have the basic service agreement for a cloud service, for example. Then a couple of years ago, we added the data processing agreement under the GDPR. Then a few years later, we added the new standard contractual clauses because of the Schrems II proceedings. Then starting this year, we had, at least for the financial sector, for example, financial services addendum for DORA compliance. And now going forward, we will in some way face a separate set of addendum for Data Act compliance. And this is how this will likely turn out in practice.
Yeah, so a significant effort, I think, ahead on the contractual side. I'm going to ask a couple more questions because and within the limited time we have left, but I think it'll be on top of mind. By when does this all need to be done? And what is the ramifications for not having done it or not having got it right?
Yeah, probably let me start with the connected products, and just let me drop one or two sentences on these contract terms to complete what Henrik said for the processing services. There is a structure in the European Data Act that is in a way helping the companies. Whether it's helpful, it's to be discussed, but the Data Act requires that there are terms and conditions for the user access and for the third-party transfer of data. And it requires, even in a B2B scenario, that the terms for these for the transfer and the access is FRAND. So it's fair, it's reasonable, it's accessible, and so that the law itself provides a setup or a scheme how to identify these fair terms. This is relevant because in a B2C scenario, obviously you have a certain threshold or a certain requirement by applicable consumer protection laws. And this is different, at least from the European perspective, in B2B scenarios. And the new law now introduce what you have to consider when you renegotiate and draft these agreements. So it's relevant to have a look at what the law is expecting here. And now you said, Scott, okay, by when do you have to accomplish this exercise? So actually, the first important step is the September 2025 that I mentioned before in connection to this user access. And it's relevant for different perspectives. So first, if you are a manufacturer of a connected device and you want to put it on the market after September this year, then you have to make sure that when entering into a contract, this can be a purchase contract, a rental contract, a leasing contract, then you have to provide certain information to the user, so to the buyer or to the one who's renting your product. This can be a big machine, for instance, right? And there is a set of requirements that transparency requirements, where you have to provide certain information about the capability of the machine, about the data that's being processed, about the storage location, the retention period, and so on and so on. So, and this again is why this data mapping exercise is so relevant. And putting together this transparency document and make up your mind how to provide it to the customer. This is one exercise. The next one is, as you can face this user requests and this user transfer requests, so third-party recipients, well, you may want to have proper legal terms in place, how to govern this process. And this is something that you should, in your own interest, accomplish by end of August this year, because at the 12th of September, theoretically, a user can knock at your door, right? And this is important. At this date, the data holders will have not automatically the right to use the data anymore, but they have to take care that they have a proper license in place, because the Data Act associates the right to use the data, the product data and the connected service data, to the user instead of the company. So I think these are my main takeaways. The data mapping exercise until September, the notice, the working on the notice, and the contractual due diligence. Which type of provisions have I in place already, and otherwise, how do I amend my terms and conditions? And this again has two layers for existing clients and for new clients, which is much easier, right?
What happens if I can't do it by all of those days?
Yeah. Welcome to Europe. Like with so many other regulations, the European legislator has introduced a certain scheme for fines, right? You know this from the GDPR, you know it from the EU Data Act. So obviously you can, even with the Data Act, face certain sanctions if you do not comply with the laws. And obviously the users can enter into litigation to enforce their rights. What's fair to say is that there has been a hassle in the many various European member states how to determine the appropriate regulator for the enforcement of the Data Act. And this has been a lengthy process in many jurisdictions, like in Germany, for instance, with regulators coming from product regulation competing with data protection authorities. And it took so long that they are probably not in place yet to have all structures in place, to have a proper claim management, that they can immediate start at September. Let me put it differently. Companies, they do not have to fear that they, by day one, get sued if they cannot comply. But like always with the implementation of very sophisticated new legislation, there will be not an official grace period. But if you look back at the GDPR in the first 2 years, the process until the fines were picking up, this took a considerable time. And our best prediction is this could be the same for the Data Act. And probably Henrik, we discussed this with regulators, right, with the data protection authorities, and in our understanding, there's a different notion whether this will be a hot topic in terms of enforcement or not. So probably you can cast some light on this as well.
Yeah, happy to, indeed. So the big question is on, will customers and users actually make use of their right to access data and to switch data processing services and to share data? So that's a big question. And the opinions here are different, so to say. Well, you see or hear from authorities to some extent that they are not already too sure on whether this will happen, actually. But then on the other hand, you also see voices that are already keen to exercise their rights. But the answer on that is we still don't know yet. So we need to see and wait once the Data Act is fully applicable, and then see what happens. There's also the option that users can lodge complaints with authorities, which are determined in the different European member states. So there's also this public enforcement angle. This is something that we will see at some point, I think, at least because there are some activists in Europe that want to try out the boundaries of the new law, I think. So this is something that we can expect.
Yeah, interesting. So maybe last question as we close. There's a lot more clearly that we have to dive into here. You both mentioned throughout this, and as I mentioned at the very beginning of the episode, there is specific applications to cloud computing, specific applications to connected products. Fortunately, we'll have opportunities to discuss both of those in additional episodes in this 3-part series so that we can cover those properly. But before we dive deeper into those things, let's just spend a moment thinking about this broadly, because this EU Data Act is coming on the heels of the issues surrounding, I think you mentioned DORA a moment ago, the EU AI Act, there is obviously the GDPR. I mean, there's so many different types of laws that are popping up within this larger set of digital regulation throughout Europe that it would be helpful to hear your perspective about how all of these things fit together. And then importantly, from a client perspective, many of them feel like the goalposts are constantly moving and changing, which makes it difficult to create some resilient and a business that will be able to scale and be able to comply without always having to go back and change your contracts, change your processes, develop new things from a legal perspective. Your thoughts on how to think about the larger developments in this space from both the particular and then the general overview.
Yeah, maybe I start. So I think many companies will perceive this as a tremendous burden, and they will look at the efforts and the investments they have to make to comply with these new laws. So this is really a stretch, and this is fair. And if you look at the teams that are on the projects, they are stretched by so many demands in various aspects. You mentioned a couple of them. Yeah, so they have been associated with a task. Let's say they are taking care about data protection in the organization. Now they are involved in a project on AI, B on a project of something what is called Data Act. So and the time they have to cover all of the duties, well, this does not expand in the same way. But if we look at the opportunities that these new laws may bring, I think if we are probably a couple of years ahead, then I think companies will see that there's many of synergy effects that they have, and probably I can. If I look at my own business that I'm doing and I have been doing over the last, let's say, 2 decades, then if you look back at, let's say, 5-6 years ago, the type of work was so different. It was more paper-driven, it was more static, and now slowly evolving, there is a more digital transformation at our company and with our clients. And I think if we understand that there is a positive aspect on that, for instance, with the data mapping, it's a nasty exercise, time consuming. You have to bring many people to the party, and it's a budget question. But if you combine it with this type of data catalog exercise, then you can make a benefit of that, because after the exercise, you are in a much better position, and then you can consider developing new digital products. So we have a client in the logistics industry. They have been discussing the ownership of data, quote unquote, for quite a long time. And they have been through the exercise of constantly revolving the terms and conditions because customers were challenging that. Now, the scenery is pretty clear with the Data Act. And going through the exercise, they have identified okay, now I know about where is my data located, what are the databases. Are there, let's say, legacy products that I should descope and put out of service? And the same with digital services. And after the exercise, I think it becomes clearer more and more that they will be in a scenario where they know their data much better and can identify new business opportunities. So I think I do not have, let's say, the positive message for the moment, because it will be a hassle, and but it is for protecting yourself against user claims and probably non-compliance allegations. But in the long run, the companies will benefit from that because it's part of the digital transformation that we are all exposed to.
Yeah, I think that's exactly right. Henrik, anything you would want to add to that?
Yeah, that's basically what we see. I mean, from a practical perspective, we really see that compliance with all those new regulations, like also the Cyber Resilience Act, for example, really requires you to involve your product team together with the legal team, and to get a perfect understanding on what your products are doing and what data you're collecting. So that's the biggest task. The good news is that we see, at least for example in the cloud computing sector, that when companies already did their homework with regard to the GDPR, there is already a basic understanding on the processes and procedures needed for that exercise. And there's something to build upon if you have for example, register for personal data. So you just need to complete it with regard to the non-personal types, which you to some extent already have in place. So, well, yeah, but I can only echo Christian. It's often felt as a burden, but our message is before you start too late, it's really recommended to start right now if you haven't done so, and to perceive it as an opportunity to get a better understanding and hold on what data you actually have access to.
Well, that is I think probably a great place to close. Christian, Henrik, really appreciate your time and expertise on this episode, and I'm really looking forward to our deeper dive into connected products and cloud computing, which will immediately follow this episode. So for listeners, make sure that you don't stop here. If this is an area that's going to impact your business, or you're interested in the future of digital transformation and regulation throughout Europe, you'll want to tune in to those 2 additional episodes. One focused on cloud providers, cloud computing, cloud-based services, which will have unique obligations under this rule, and another episode around connected products, effectively every product that's connected to the internet, and what the unique application is for those products. So tune into those episodes. But in the meantime, Christian, Henrik, really appreciate your time giving the overview of the EU Data Act. I'm sure there will be a lot of additional conversations in the future.
Thank you.
Thanks, Scott.
With that, I'm Scott Loughlin. This is the Data Chronicles, and those were your data points.